Take a look at this. Ripple slams SEC. The term crypto asset security has no legal basis. Chief Legal Officer Stuart Alderoty of Ripple has taken aim at the United States Securities and Exchange Commission, citing a legal document that used phrasing that was misleading in his opinion. The term crypto asset security, which appeared in the SEC's latest papers connected to the FTX bankruptcy case, was the target of Alderoty's attack. The term was coined by the SEC to sway court judgments, according to Alderoty, and it is not based on any statute. While discussing the FTX bankruptcy plan, Alderoty provided screenshots of the SEC's filing in which the agency states its rights with regard to the allocation of assets, including crypto asset securities. This document, which was filed with the United States Bankruptcy Court for the District of Delaware on August 30th, 2024, states the stance of the SEC about FTX's planned Chapter 11 plan. Crypto asset securities are part of the debtor's portfolio, which the SEC notes could be dispersed or monetized as per the plan. The term crypto asset security is used by the SEC, according to Alderoty, although this is both misleading and not supported by law. As part of the bankruptcy plan, the SEC's petition also discusses the potential of creditors receiving stablecoins. According to the organization, stablecoins tied to the US dollar are now considered cash and may be involved in the distribution process. Still, Alderoty is concerned about the larger picture and how the SEC's phrasing could influence legal conclusions in a manner that goes against precedent. The cryptocurrency sector as a whole is worried about the SEC's attitude to digital assets and regulatory overreach, and Alderoty's criticism is reflective of that. I think the SEC is trying to expand its regulatory authority without strong legislative support by coining and utilizing terminology like crypto asset security, according to Alderoty. He contends that this might cause judicial decisions to be based on speculation rather than substantial evidence, and that it further confuses the issue. The SEC's goal of classifying XRP as a security caused significant harm to the cryptocurrency and subjected Ripple to years of litigation. Although the SEC was unsuccessful in this particular initiative, it has not prevented them from continuing to pursue additional legal proceedings. By questioning the SEC's wording and its consequences, Alderoty is fighting for better and more uniform regulations for the cryptocurrency sector while simultaneously protecting Ripple's interests. Ripple has decided to postpone paying the SEC a penalty of $125 million. The United States Securities and Exchange Commission and Ripple have reached an agreement that will delay the payment of $125 million in penalties. The SEC issued the penalty order to Ripple on August 7th, but the business did its best to delay really paying for it. Over this time, the corporation suggested depositing 100% or around $139 million into a bank account. This account will remain outside of Ripple's control until the dispute is resolved. This new information raises the possibility that the SEC will appeal the Ripple case. Brad Garlinghouse, CEO of Ripple, has previously said that the company considered the court's decision a win. The possibility of an appeal to the SEC, on the other hand, raises the possibility that further time may be needed to decide the issue. Ripple decided to take a strategic move. An element of Ripple's comprehensive financial strategy is the decision to delay penalty payment. The business is taking note of the court's decision about the penalty and ready for the appeal process to give itself more leeway. Ripple's strategy shows that the corporation is serious about meeting its financial commitments and getting ready for the appeal procedures all at the same time. The CSE's potential for an appeal after the SEC found that Ripple's XRP sales were unlawful. They wanted a heavy fine from the cryptocurrency exchange. Nonetheless, the judge ruled that XRP is not a retail-grade security. It is still possible to think about appealing to the SEC even after this decision. The fact that Ripple has chosen to postpone paying the penalty until the appeal procedure is over suggests that the situation is still unresolved. This request that Ripple has made is dependent on the court's official approval, which is now pending. It will not be legitimate to postpone the ruling unless Judge Anna Satori's gives her assent. However, the strained relationship between the two parties has been momentarily eased by the SEC's approval of this request. Yeah, the case that Ripple was embroiled in with the SEC began in 2020. The case's influence on cryptocurrency markets and the dynamics between regulatory agencies has persisted since then. As the legal process progresses, both sides are engaging in substantial strategic maneuvers. The question of whether XRP constitutes a security has been the subject of heated debate for many years. The tactical moves made by Ripple and the security criteria adopted by the SEC shed light on the regulatory challenges that other cryptocurrency startups are encountering. The move made by Ripple might set a major precedent for other cryptocurrency companies if it is allowed. Next up for Ripple's $125,000 flying appeal is a decision to delay the matter by the SEC. In response to a court order from August 7th, Ripple Labs has filed a letter seeking to halt the payment of $125 million related to its ongoing litigation with the U.S. Securities and Exchange Commission. It was suggested that 111%, or about $139 million, of the verdict be held in escrow until 30 days following the deadline for appealing the decision or resolution. The Commission has indicated its approval of Ripple's request to extend the payment deadline beyond September 6th. The suggestion that an appeal will be filed is implied by this. This drawn-out case has become a watershed moment in the history of cryptocurrency regulation, and the prospect of an appeal has only served to further complicate matters. In order to delay Ripple's $125 million fine, the CC's reached an agreement. The most current filings indicate that the court has issued a stay pending further proceedings concerning the execution of the monetary judgment part. The stay imposed by the order will remain in force until either the deadline to appeal the judgment, which is 30 days after the deadline, or the Court of Appeals issues a determination on the appeal. The court ordered Ripple to put $139 million, or 111% of the penalty, into an account that earns interest at Trust Bank with its attorney overseeing the account's management. The defendant would retain ownership of the property, but they would not have any say over the amount that was deposited, according to the statement. According to the court's decision, the money won't be released until either Ripple and the SEC agree on how to use it, or until further court orders are issued or an appeal is resolved. After receiving Ripple's letter asking a postponement of the monetary element, the SEC approved the proposal. This new information has raised the possibility of an appeal, according to attorney Fred Ruspoli. It was pointed out to him that just because a 100 monetary judgment was agreed upon and frozen doesn't mean an appeal will be filed. A trust fund with the proposed $139 billion in assets is not established. He proceeded by saying that the SEC should not be avoiding questions from Ripple's legal team regarding an appeal of the verdict. While it's true that the odds have gotten higher, the lawyer did point out that anything can happen if an appeal is filed. The perception that an option will not be made until 2026 has been given by Ruspoli in the lawsuit between Ripple and the SEC. However, the situation's impact has been greatly mitigated due to the Commission's litigation against cryptocurrency-linked exchanges and its assertion that multiple tokens constitute securities. Despite only 32 days remaining for the appeal and the SEC's silence since August 7th, the market is seeing an increasing lack of appeal propaganda. The $125 million fine has been postponed by Ripple Labs as a result of the latest development in the company's legal dispute with the SEC. Despite the SEC's hints about potentially appealing the August 7th ruling, Ripple's legal team has properly requested the postponement of the substantial payment. Both teams are presently deciding what to do next in what might be a collision that changes the game entirely. An appeal will not be lodged in the near future. Trading advice should not be construed from the data that has been supplied. You should not put your money into anything that relies on the data presented here. It is highly recommended that you consult an expert and do your own research before making any investing decisions.